This case might look like just another routine child support hearing, but don't let that fool you. What unfolds here is a tense legal showdown between a defendant attempting to challenge the court's authority and a judge who isn't letting procedural arguments derail the process. Right from the start, we see a familiar strategy, invoking a special appearance to contest jurisdiction. But here's the twist: timing, documentation, and legal understanding all collide in a way that could completely change the outcome. As this hearing progresses, pay close attention to how the defendant tries to leverage technicalities like service of process and procedural rules to avoid liability. But the big question is, are these arguments legally sound, or are they just delaying tactics? And more importantly, how will the judge respond when these claims are put to the test? This isn't just about numbers. It's about legal strategy, courtroom control, and understanding how the system actually works. Stick around, because what starts as a procedural argument quickly turns into a decisive ruling with real financial consequences.
Okay. It has not made it to the court file. As Ms. Foote, do you see it? Is it in the documents?
No, ma'am, I don't, but I will check e-file and see if it's in there by any chance.
Did you electronically file it, sir, or did you walk it?
I did. I e-filed it, and I've got an. I can get you the envelope number.
I think you have emailed it to us. Is it the affidavit of truth?
Yes, I emailed it to you as well. In addition, I e-filed. I've got an envelope number if that would help. Would the clerk like the envelope number, or?
I don't need it. I can check by the case number. I'm checking right now. There is a demand letter as the description. It has not been accepted. I'll get it accepted right now.
Thank you.
And Judge,
It's been accepted. It should come up in the system in just a few minutes.
And Judge, you mentioned you're coming outside of Montgomery County. Specifically, where are you coming out of?
I am in Harris County, and I'm doing this pursuant to the Family Code 201.1045.
Thank you.
My clerk is in Montgomery County today.
Okay, thank you.
Thank you.
Judge, it is in the file now.
Showing.
Judge, you might need to go out of the case, then come back in.
I found it in the documents tab, so I think I can pull it up that way.
Okay, thank you.
I'm going to take a moment to read this. Mr. Dean, why don't you proceed on your pleading? Though I'm going to say I don't believe this is timely, but you can explain to me why it is.
Okay. So Judge, so all of the times that I've came into court, I've always mentioned that I'm under special appearance, and the sole.
Can you explain what that means to you?
Yeah, well, I actually had the definition from Black's Law Dictionary instead of giving you my interpretation of it. All right. So under Black's Law Dictionary, it says special appearance is when a defendant appears in court solely to contest the court's power over them without submitting to it, often called limited appearance. General appearance is basically when someone comes into court accepting the jurisdiction and so forth.
Okay, so can you explain why the court does not have jurisdiction over you?
Yeah, so because civil procedure was not followed under Rule 107, that identifies that the court doesn't have jurisdiction to proceed with a judgment because the civil procedures was violated.
Would you like to flesh that out more, sir, or do you want to leave it at that?
And you mean in terms of
what you're saying?
Right away, You can see the defendant positioning himself with a special appearance, which is often used to challenge the court's jurisdiction. But here's the critical detail. Just saying those words doesn't automatically protect you. Courts look at how and when these claims are raised. If they're not filed properly or on time, they can be dismissed almost instantly. What's interesting here is that the judge doesn't shut him down immediately. She allows him to proceed. That's actually a sign of a fair courtroom process, but it also sets up a key moment. Will he be able to back up his claims with actual legal substance, or will this fall apart under scrutiny?
Happen? Or should we go through them one by one?
So there's not a return to service on file, Your Honor.
There's an executed citation, a constable return of service and citation. It was filed with the court, I believe, June 16th of 2025.
Was that under e-file?
It's in the court file. I'm not sure how it got here.
Is Mr. Dean done? Is it?
Yeah, Mr. Dean, are you looking at something, or is there more you'd like to say?
No, I'm sorry,
about
Judge.
what? Okay,
I'm sorry,
I thought you were
Judge.
looking at something. I wanted to give you time to look for what you needed to prepare.
Oh, okay. I'm sorry. I thought I was waiting on you. I thought you were doing something to where.
No, I was just waiting to see.
Okay. So the document you're looking at, Judge, you're saying it's on the court files?
In the court file, yes.
In the court file. So I'm not seeing that under e-file. And when I looked up that information, there was.
Are you in research? What system are you using to look up information? Because it's possible it's just not there because it's not the official court file.
Okay.
But I don't know what you're looking at. Ms. Khan, are you able to see it in your accesses?
I can share the screen, Judge, if you would like to show where he was served. I think we did this last time too, though, at the last hearing. And we acknowledged that it was service by posting on the door. He said he didn't get a copy of it. And so I emailed him, and he acknowledged on the record that he had received it. And so we've already covered all of this.
Yes, Judge, and I had an objection to that, still identifying that's not return of service under civil procedure.
Is there anything else you'd like to say, Mr. Dean?
Ms. Khan was saying that she was going to share that document with us.
I mean, I feel like we've already covered all of this, but.
We haven't. The last time we were here, we did not see that document.
You may pull it up, Ms. Khan, so he can see it. If it's...
This is the second page. First page is just the citation, and then this is where he stated where he left it.
So I was speaking to Ms. George, and she is stating that this is part of the citation. It's not the return to service.
I'm sorry, who's Ms. George?
She is the child support case representative. Tanisha George. So this document is the actual citation, Your Honor.
According to the child support officer.
Yes, ma'am.
Okay. Ms. Cott, is there anything you'd like to say in response to his allegations?
Judge, he was served by substituted service, and it is duly on file. There was proper motion filed, so following the rules of civil procedure. And also his issue was saying that he had not received a copy of it. He has since received a copy of it, accepted that copy. So at this time, I would state that we should be able to move forward.
And I've got an objection to that, Your Honor. As long as civil procedure is not followed at the very beginning, there's no reason for a judgment because the civil procedures was not followed initially, according to Rule 107.
And Ms. Baskins, is there anything you'd like to say?
My understanding is we're just confirming arrearages today. I'm not sure what
Now we're getting into a crucial procedural issue, filing. The defendant insists he submitted documents, but the court hasn't received or accepted them yet. And this is where many people misunderstand the system. Filing something doesn't mean it's officially part of the case until it's processed and accepted by the court. This small detail can make or break an argument. If the document isn't properly in the record, the judge may treat it as if it doesn't exist at all. So the question becomes, did the defendant rely too heavily on paperwork that wasn't fully processed?
Judge Baker, I'm sorry, apologies. Judge Baker, on this recording here, is it public record? And where can I go to get a copy of the recording?
You would have to request that we send it to you, sir.
Okay, thank
We
you.
don't post it online or in a file for the world to see. It's not public record.
Okay,
And it's
that's-
only an audio recording. We don't have anyone to transcribe or officially do any of that.
okay, that's good to know. The last time we were on here, someone recorded and posted it online.
Okay. And people, we broadcast on YouTube, sir, and people do that. They are not supposed to. As you can see, there's a little screen up that says recording is prohibited. If you know who did it, please do let the court know.
Okay, thank you.
But right now it is on YouTube, but I take all my YouTubes down almost immediately following the hearings.
Okay.
They're not posted for perpetuity online. But if you do know who did it, please let us know. And nobody here should be doing that. Ms. Baskins, you should not be doing it. Mr. Dean, you should not be doing it. No one from the Attorney General's office or the clerk's office should be doing it. And nobody who is watching right now should be doing this.
Okay, I definitely did get some hate
I'm sorry about that.
harassment items with it.
Yeah, and I don't like it being up there either because the same applies to all of us up here. We all get that, including me. So,
yeah.
But we do have open courts in Texas, and if we were live in the courtroom, anyone could come and watch it as well. So this is how the people who make the decisions have deemed we comply with that provision. Okay, I'm sorry. Let me go back to what I was thinking. Okay, I am denying the special appearance. I'm finding the return of service is on file with the court and on its face valid. Also finding a motion to quash could have been filed if there was a claim of defective service. And under Rule 122 of the Rules of Civil Procedure, if it was quashed, you would be deemed served by 10 a.m. the Monday next after the expiration of 20 days, the regular answer time. And it would have, at that point, you'd be in the lawsuit. So I'm not finding that there's anything that's been pled or argued that would show that the court does not have jurisdiction over you, sir. There's a prior order in this case. So I do find jurisdiction is proper and the return of service on its face is valid. You may proceed, Ms. Khan, with the motion to confirm arrears.
Yes, Your Honor, I would offer the pay records. We have two in this case. There's one from the Harris County cause number and then one from the Montgomery County cause number. If I may share the screen.
You may.
Mr. Dean has been sent copies of these today via email.
Okay, wait, before we share screen, does anyone
Your
have any objection? I'm confused as to, since the case was transferred here, I'm confused as to why there's two pay records. But Mr. Dean, what is your legal objection?
I have an objection. I was here under special appearance and I'm prepared to be here under special appearance. Now that the court is transitioning this to a general appearance, I request time to prepare.
So you were given time last time to prepare?
Under special appearance, Your Honor, and I did.
But that has been denied. This case was filed November 27th. We're already after over a
Here
year.
comes the core of his argument. He's claiming the court lacks jurisdiction due to improper service under procedural rules. On paper, that sounds like a strong legal defense. Proper service is absolutely required in civil cases. But here's the catch. Courts don't just take your word for it. They rely on official records. And if the court file shows that service was completed, even through alternative methods like posting, then this entire argument starts to weaken. So now the tension builds. Does the official record support the defendant, or is this argument about to collapse?
Of being dismissed is not evidence.
Ms. Baskins, is there anything you'd like to say?
All right. I mean, this is like our fourth or fifth time to reset this. I feel like the matter at hand, simply confirming arrearages, is we're not arguing about anything else. I feel like it's pretty straightforward.
I'm going to deny your request, sir, and we're going to proceed today. We're going to begin, and just a few housekeeping items. I am an associate judge. You do have the right to a de novo hearing before the referring court regarding decisions I make. As I said earlier, nobody should be recording this. There should be no audio recording, video recording, or broadcasting. Everyone should be speaking in civil tones, which you are doing, so thank you for that. And we generally take testimony, so one of you will be asked questions at a time by the AG. Since you're both representing yourselves, you'll both be given a chance to speak as well at the end. And then just be aware, aside from things that have been said before me, I don't know what you all have discussed in the back or on calls with the AG's office, so just be aware I'm not with them. So you might be asked questions or things that you've discussed previously. Just be aware that that's how I do get the information. And so does anyone have any legal objection?
I've got an objection, Your Honor.
Okay, what is your objection? Can I finish what I'm asking that what you're objecting to?
Yes.
My question was, does anyone have any legal objection to the pay record or the pay records that Ms. Khan is attempting to admit?
I've got an objection to it, Your Honor.
Okay, what is your legal objection?
So Ms. Khan is a third party in this case. The case is between the state of Texas and myself, and I'm wanting to know, Ms. Khan is a third party submitting evidence. Is the state of Texas submitting any evidence as well?
I'm sorry, is the state of Texas doing what?
Submitting evidence. It's two separate entities, Your Honor. Ms. Khan is with the Attorney General Office, and according to the communications that they've been sending, they are a third party. And the case here today is between myself and the state of Texas. I'm wanting to know, is the state of Texas providing any evidence, or is Ms. Khan providing the evidence?
I don't think you understand. Ms. Khan represents the state of Texas. The Attorney General's office is part of the state of Texas. And I'm overruling your legal objection. Do you have any legal objection to the documents?
So no, but I do have another objection, Your Honor.
Okay, what is your objection?
So the second objection is that if we're going to move further with the case, I'm requesting a trial by jury.
Okay, that has not been timely requested, nor are you guaranteed one in this case. So I'm denying that request.
I've got an objection to that, Your Honor. Since as of today, we're moving forward with general appearance, I'm requesting a trial by jury because this is a new appearance. And I'd like to get time to prepare for a trial by jury.
Ms. Khan, do you have any response to that?
The judge in Texas, a jury doesn't determine issues related to child support.
Yeah. What is the jury issue? I'm not sure a jury would hear a confirmation of arrears.
Sure, I'm just objecting to exercise my right to trial by jury.
I would argue that child support is a legal issue.
This is a pivotal moment. The state steps in and clarifies that service was already addressed in a prior hearing and even acknowledged by the defendant. That's huge. In legal terms, once you acknowledge receiving notice, it becomes extremely difficult to argue improper service later. It's almost like closing the door on your own defense. So now ask yourself, if the defendant already admitted receiving the documents, can this argument about improper service really hold up?
It's Judge's Family Code Section 105.002 lists the issues that may or may not be sent to a jury. And it does say 105.002C2 states that the court may not submit to the jury questions on the issue of support under Chapter 154 child support. and several other things, but that's the one.
Yes. Thank you. And I'm finding this request not timely either. Based on 105.002, this is not a jury issue, and it is not a timely jury request. Jury requests must be made in writing. This is not in writing either.
Muted.
And so, does anyone have any legal objection to the pay records being admitted into evidence?
Your Honor, I know that you're going to proceed from now on, but for the record, I'd like to state I do have an objection for the rest of the proceedings.
Overruling your objection. Ms. Baskins, do you have any objection to the pay records being admitted?
I do not, Your Honor.
Okay, I'm admitting the pay records into evidence as State's Exhibit 1 and 2.
Judge, if I may share the screen, I have. I'm sorry, I lost it now. Did it share? It didn't do it.
It is shared.
Okay. Is this the
Looks like the Harris
the
County?
2021? Yeah. So Judge, this one shows as of November 30th, child support arrears of $12,353.91. I'll stop. And then,
Can I look at that closer? So what is are you going to ask questions about this so I get more information?
I can a little, yes, Judge, but I was just going to show the numbers first. So this is
Okay.
as of November 30th under the Harris County cause number, there's 12,353.91.
Okay.
And then under the Montgomery County pay record, there's child support, medical support, and dental support. As of November 30th, child support is $2,610.62.
Sorry.
Medical
Child support was for what?
$2,610.62. The medical is $1,601.81. And then dental is $159.98.
Okay.
Okay. And at this time, I would call Mr. Dean. Mr. Dean, can you state your name under?
Yes, I am the man Zahir Dean.
And do you understand that y'all had a divorce decree in Harris County? Is that correct?
Yes.
And then it was transferred to Montgomery County, and y'all got a new order in a suit affecting the parent-child relationship that changed the amount of child support. Is that correct?
Yes.
And for whatever reason, that order didn't combine the arrears from that prior order from county. And so today we're looking to combine both of those together into one number. So instead of 2,610.62 and 12,353.91, we combine it under one cause number so you don't have two different cases paying into, and it would be 14,964.53. Are you in agreement with that?
I don't know what you're like. I don't know the details of what you just said.
Okay. So do you understand that y'all had two different cases? Y'all had a case in Harris County, the divorce decree, correct?
And there it is. The judge delivers a decisive ruling. The special appearance is denied, and jurisdiction is confirmed. This moment is critical because it shifts the entire case. Up until now, the defendant was trying to avoid the court's authority. But with this ruling, that strategy is officially over. The case is moving forward whether he's ready or not. This highlights a key legal reality. Procedural arguments must be precise, timely, and backed by solid evidence. Otherwise, they can collapse instantly, just like we saw here.
And the information that you've shared with us earlier on the pay records, did you pull that directly from the child support account under the Attorney General? Okay. Yeah, that's the tool that they've used to garnish wages.
Okay, so are the pay records correct so far as you know?
I haven't reviewed it, so if that's the tool that they're using for the pay records, then that's the tool that they're using for the pay records.
Have you made any direct payments to mom, given her cash instead of paying through the OAGs?
No, I'm court ordered not to. I'm court ordered to directly pay through the Attorney General's tool.
Okay.
Any payment towards mom directly would not be considered a payment.
Okay. So do you have any reason to dispute the numbers that we're saying that should be combined together into one judgment?
I do have an objection based off of me being here today based off of the initial rulings from my objection.
Okay. But you don't have anything to say about the numbers?
No.
I'll pass the witness, Sharon.
Okay. You may call your next witness.
I call Ms. Baskins. Ms. Baskins, I think you're on mute. Can you state your name?
Adrienne Baskins.
So today I'm just trying to combine the arrears. I want to confirm the child support arrears as of November 30th for $14,964.53, medical support arrears for $1,601.81, and the dental support arrears for $159.98. Are you in agreement with all of that?
Yes, ma'am.
All right. I pass the witness, Your Honor.
The state does not represent either of you, so I'm going to give you both a chance. If there's anything additional you'd like to say that you think I need to hear about the arrears and what the state is requesting. Actually, Ms. Khan, why don't you do a quick summary, because I think you have one already of what you're asking for, and that way everyone will know exactly what you are asking for if they want to object to it or contest it.
Yes, Judge, we're just asking confirm arrears as of November 30th, 2025. Child support arrears would be the amount of $14,964.53. The state would ask for a payout of $100 a month. Medical support arrears of $1,601.81.
Sorry, can you slow down a little so everyone can follow that? Medical is what?
Medical is $1,601.81, and the state is asking for a payback of $20 a month. And then the dental support arrears of $159.98, and we're asking for a payback of $10 a month towards that.
Okay. So now that everyone's read, would you like to respond to that request?
Yes, Judge. I've got an objection. I saw the Attorney General's data for the actual child support, but I did not see the supporting evidence for the medical, dental, and so forth at this time on how that number came about.
Now the defendant switches tactics, requesting more time after losing the jurisdiction argument. But here's the issue. Courts don't typically allow delays just because a strategy didn't work. From the judge's perspective, this case has already been ongoing for over a year. Granting another delay could be seen as unnecessary and unfair to the other party. So the judge faces a balancing act, fairness versus efficiency. And as we're about to see, she's not inclined to slow things down any further.
Take judicial notice of that order, including page 20 of 29. Orders Zahir Dean to pay Adrienne Daniel Baskins as child support the amount of $318.80 per month for the cost of health insurance, with that first installment being due and payable on August 1st, 2024, and a like installment being due and payable on or before the first day of each month thereafter. So that's where the cash medical comes from, and the dental support starts on page 21. And there's a paragraph on page 22 that says Zahir Dean is ordered to pay Adrienne Danielle Baskins as child support the amount of $30.95 per month for the cost of dental insurance. And then it continues with that same language.
So,
if that helps. So I take judicial notice of that 2024 order. And you may continue, Ms. Khan. Since I had it up, I figured I would help you there.
That would, and then it's also reflected on the same pay record that we had already discussed.
So I've got a clarification that needs to be made, Your Honor.
Okay.
So when they say that I needed to pay that, right? Is it under the impression that it's going to be pulled under a garnishment of my paycheck, or?
Gonna stop for a moment and say I am not on the witness stand, but I'll give you just some general information. When child support is due, it is due. I believe there's even a section in here that says it's all due and owing. I usually, if I'm setting child support, have been known to give a speech something like this. You are responsible for making your child support payments. Generally, the AG's office will issue a wage withholding order. If you don't have the AG's office in your case, usually a private lawyer will issue a wage withholding order. But you are ultimately responsible for the payments, not that wage withholding order. And so what I always encourage people to do is to look at their paychecks, look at what is due, make sure the full amount, especially when modifications happen. Often things don't happen quick enough. I don't know why. It's not always the AG's office's fault. Sometimes it's the employer, but for whatever reason, it doesn't always quickly happen. And so people need to look at paycheck stubs and look at what's coming out and look at what's due and pay anything extra that's not due. Not everyone works for a company where you can withhold. Some people have jobs that they have to make they have to make payments themselves through the SDU, where that wage withholding
This
order
moment reveals a fundamental misunderstanding. The defendant refers to the Attorney General's office as a third party, but the judge quickly corrects him. The Attorney General represents the state. This is a big deal because it shows a gap in legal understanding. In cases like this, the state is directly involved, especially in child support matters. So when arguments are built on incorrect assumptions like this, they tend to fall apart quickly in court.
The amounts that were due under the Harris County order, they stopped once August 1st came around of 2024, I believe it is.
Yes. So
There's no double dipping.
I think it looks like it even, yes. Last one was April 30th, 2025. Oh, well. Oh, no, I see it. July 1st, 2024 was the last time we billed for that one. And then I believe.
And then this starts up on August 1st of 2024 for the Montgomery.
Yeah.
Okay, so that they.
Yes, the last time we billed him was July 1st, and then it switched to the other one.
Okay, I'm going to confirm the child support arrears based on. Well, actually, what I'm going to do, Ms. Khan, I'm concerned about interest, and I'm not sure what will happen. So I'm going to confirm the arrears in the Harris County cause as of July 31st of 2024.
Okay.
Here in Montgomery, though, so that you can enter into your system the judgment as of that date. And then the Montgomery numbers will just roll from there. Because I don't want to.
But it's actually higher, which is weird.
Is it because some payments were made since then, or?
Yes, there were payments made since then.
That's why. Okay, so those payments will still accrue, and it'll all go down. Correct?
Yeah.
Okay. And so as of, did you understand? So what I'm going to do, sir, I don't want to possibly double dip on interest. I don't think it's a doubling, but I do think mathematically this will be less interest in the long run. I could be wrong. From the arrears that were due based solely on the Harris County order that is now transferred to Montgomery and is here in Montgomery as of July 31st of 2024. So that will be the starting of the pay record for Montgomery now is whatever was due under the old order. And then anything new that accumulates.
Now we shift from legal arguments to financial reality, the actual numbers. And this is where things become concrete. The state lays out the arrears clearly, combining amounts from two different cases. What's telling here is that the defendant doesn't dispute the numbers themselves, only the process. That's a critical distinction. In court, if you don't challenge the accuracy of financial records, the judge is far more likely to accept them as fact. So the big question is, by focusing only on procedural objections, did the defendant miss his chance to challenge the actual debt?
The child support judgment as of July 31st, 2024. There was no Montgomery County obligation at that date, so there's no confusion there. So the judgment against Mr. Dean in the amount of $12,679.31 as of July 31st, 2024. I'm ordering that he pay that back at a rate of $100 per month, beginning January 1st, 2025. With step-ups as child support goes down. So the child support's going, let me get those numbers.
Just go up to 1994. What is it? Child
So
support.
there's 2 children. There's a step down.
Oh, yeah, there is.
So the first one is 1893. 4 minus.
Goes to 1731.
So it looks like 478.67 will be the first step up.
Okay.
And then the next one would be $1,993.34. Until paid in full. Does that make sense for drafting?
I think so.
Okay. And so the state's going to draft the order based on my ruling today, and they'll be circulating it to y'all through DocuSign to review and sign off on, and then you'll be free to go. But thank you all for coming in, and good luck with everything going forward.
Hey, Judge, what I'd like to do is once she sends it through DocuSign, I like to print
This
it out.
case is a textbook example of how courtroom strategy can make or break your position. The defendant attempted to challenge jurisdiction and delay proceedings through procedural arguments, but ultimately, those arguments didn't hold up under scrutiny. The judge confirmed that proper service was completed, denied further delays, and moved forward with the financial evidence. In the end, the court issued a clear ruling, over $12,000 in confirmed arrears, with structured monthly repayments moving forward. The bigger takeaway? Understanding legal procedures isn't just about knowing the rules, it's about applying them correctly, at the right time, with the right evidence. Otherwise, even confident arguments can quickly unravel in court. Now we want to hear from you. Do you think the defendant had a valid argument, or was this just a delay tactic from the start? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.